This is the story of a defendant whose excuses are so unbelievable, you have to hear them to believe them. Samantha Venegas is facing serious drug charges, but her biggest immediate problem is simply showing up to court. Over the course of multiple hearings, she will test the limits of one judge's patience with a masterclass in tardiness and deflection. From misplaced keys to fashion emergencies, her reasons for being late become more and more absurd. But as the court system closes in, her excuses begin to crumble, revealing a far more serious reality. She's on trial for possessing a massive quantity of drugs, with a potential sentence of life in prison. Will her attempts to delay and deflect save her, or has she finally run out of time and excuses? Stick around, because this case takes a turn you won't see coming.
Hello, where is she?
I don't know, Your Honor. I visited with her in jail. I sent her notice of setting. She apparently got out on bond. I don't know where she is. I called her in the hallway.
All right, just give me 1 second.
I made an announcement, Your Honor, and she did not know how.
All right, this hearing was scheduled at 9 a.m. It is now 9:40 a.m. The court called the docket at 9 a.m. Ms. Venegas did not answer the docket. Deputy Laura, did you make an announcement for Ms. Villegas?
Yes, Your Honor, I did. She is not in the hallway.
All right, defense, have you had contact?
Not recently, Your Honor. I letters, yes, but because the letters didn't come back.
All right, state.
State's requesting a bond for virtually.
All right, that will be granted in each case. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Yes, ma'am.
All right, thank you.
Be excused.
Yes.
Thank you.
All right, why were you late?
I couldn't find my
Ma'am,
house keys.
step out to the front. Mike.
Oh,
Speak loud so she can hear you.
I couldn't find my house keys, ma'am. I just ended up leaving the house unlocked.
All right. All right. Probably need to find the keys. All right, then we'll go back on the record. The court is recalling 2024 CR 008054 and 2024 CR 008052, State versus Samantha Venegas. Could I have parties announced for the record?
Jason Garrett for the state, Your Honor.
Denny Callahan.
All right, and you're Miss Venegas?
Yes, ma'am.
All right, the court had entered a bond forfeiture and remain without bond at 9:40 because the defendant was not present. Any objection to the court recalling that order? State? And defense, I'm assuming you have no objection.
Oh, Your Honor.
All right, that will be recalled.
After failing to appear for the 9 a.m. docket call, leading the judge to forfeit her bond, Samantha Venegas finally strolls into court at 9:40 a.m. Her reason for being nearly an hour late? She couldn't find her house key. The judge, clearly unimpressed, recalls the bond forfeiture, but sets the tone for what will become a recurring theme. This isn't just about being late. It's about a fundamental lack of respect for the court's time and authority. For now, the defendant gets a pass, and her case is reset. But this is just the first test of the judge's patience. And as we're about to see, this defendant has a habit of pushing her luck.
Where are we on discovery?
We have everything, Your Honor. We're getting closer to an agreement. I suggest one more reset.
You cannot make this up. After being warned about her tardiness at the last hearing, the defendant is late yet again. And this time, the excuse is even more stunningly absurd than the last. She claims she wore the wrong shoes, which made her walk slowly because she was afraid of falling. At 44 years old, this is the reason she gives a criminal court judge for failing to appear on time. The judge is visibly astounded and immediately reminds her that this isn't a joke. A bond forfeiture was already issued for her once before, and it was recalled as a courtesy. Now she's standing here talking about her footwear. The judge lays down the law in no uncertain terms. Be late again, and she's going into custody.
The deadlines reset.
All right, Ms. Ferguson, can I have a 30 days reset for plea deadline date? All right, we'll be back on October 24th. Once you sign the reset form, you will be excused. Thank you.
Thank you.
All right, why were you late for court?
There's no, there was no excuse really. I mean, the excuse that I have is, it was a stupid excuse because I wore
No,
the wrong
what's your
shoes.
stupid excuse?
I wore the wrong shoes and I was walking really slow because I didn't want to fall. And I shouldn't have worn these shoes. I
Okay, so here's the thing. This is what you have to understand.
apologize.
This is what you have to understand.
The judge has given her a final, direct warning, and a jury trial date is now officially set for November 12th. The defendant has used up all her goodwill. She's been late twice, offering flimsy excuses that have worn the judge's patience thin. The ultimatum is clear: show up on time for the trial or a warrant will be issued for her arrest. This is a major turning point. The games are over and the consequences are now very real. What do you think will happen? Will she finally take the court seriously, or will she push her luck one last time? Let us know your predictions in the comments below.
Dan, how old are you?
I know, I'm 44, ma'am.
All right, you're 44. On September 24th, there was a bond forfeiture issued for you because you were a no-show and you came strolling in at 9:40 a.m. And at that time, it was recalled. Your attorney came back and it was recalled and you're late again. Do not be late for this court again. Do you understand?
Yes, ma'am.
If you're late again, then guess what's going to end up happening? We're going to call it. Your attorney, he's not looking at going into custody, it will be you. You understand?
Yes, ma'am.
All right, counsel, where are we on these cases with discovery?
No problem. We're finished with discovery, Your Honor.
Okay. State, were you able to tender an offer?
Yes, Your Honor.
Yes, Your Honor. Last time.
Okay.
My mistake, Your Honor.
All right. So we were here and I do see that the offer was tendered and we were coming back today for a plea deadline date.
I believe it's correct, Your Honor.
All right. So are you asking for a jury trial?
Yes, Your Honor.
All right, Ms. Ferguson, I need a jury trial date. It's a drug case. It should be fairly short. How much time do you think?
2 days, maybe.
2 days, maybe. All right, your jury trial is November 12th. If you are not on time, a warrant will be issued. Do you understand? Unless there's good cause.
Yeah.
All right, thank you. All right, once you sign the reset form, you are excused.
Okay, thank you.
Thank you.
Thank you.
All right, everyone, I'm going to call the docket. So when I call your name, you need to stand and let me know you're here. If you don't answer or stand, I'm going to assume you're not here and a warrant may be issued for your arrest. Samantha Venegas. Oh, look like we're going to have a busy day.
First row, ma'am.
All right, Samantha Venegas.
May I address the court?
Yes.
Ms. Venegas would like to hire her own attorney.
The defendant is now trying a new tactic, blaming her court-appointed lawyer. She claims she feels like he just wants her off his case, but the judge immediately shuts down this line of argument with a brilliant explanation of the legal system. She explains that court is about facts, not feelings. An attorney's job is to handle the legal facts, receive discovery, convey offers from the state, and prepare for trial. Their job is not to be a touchy-feely friend or a personal secretary who calls with reminders. The judge, drawing on her experience as both a prosecutor and defense attorney, makes it clear that the defendant's lawyer has done his job. This is a classic attempt to deflect responsibility and create a reason for delay, but this judge isn't falling for it.
All right. Then you'll need to be back here this afternoon.
Well, I didn't mean like hire one right now, ma'am. I was
Just when you thought it couldn't get any more predictable, it does. At the start of yet another court session, the clerk calls the name Samantha Venegas, and the result is met with resounding silence. She's a no-show. Again. This comes after multiple direct warnings from the judge, a near arrest for her previous tardiness, and a lecture on personal responsibility. Her failure to appear is no longer just an inconvenience. It's a pattern of blatant disrespect for the legal process that she is entangled in. Her bond is active, meaning she is not in jail. She is simply choosing not to be here. The tension in the courtroom is palpable as everyone waits to see how the judge will handle this latest stunt.
I feel, even if I get another court-appointed attorney, I feel I don't feel like he just wants me off his case. So that's how I feel. And he hasn't done nothing for me.
Well, let me
to
just
help
tell you, let me stop you right there.
Yes, ma'am.
So in this cases, it's sort of like in sports. We shouldn't be dealing with feelings. We're just dealing with facts. These are the facts. And I'm speaking to you from a person who's been a defense attorney and a person who's been a prosecutor. Sometimes we want our attorneys to be touchy-feely. We want them to sit down, walk us through everything, hold our hands. There are some attorneys who will do that. There are some attorneys who will be your secretary. They will get your calendar together for you, call you and say, remember, you have a court setting, please be here. Other attorneys, they don't do that. Now, what I can tell you, your attorney has no duty to call you and tell you there's a court setting unless they change your court setting. Otherwise, everybody knows when their setting is. With your cases in this court, I require that your attorney receive all discovery. He's received all discovery. Then I require that the state give an offer. State has tendered an offer. You can either accept it or reject it. Here's the thing. Your attorney can't force the state to give you something that you want. If you want your case to dismiss, your attorney can present information to the state the reason he thinks it can be dismissed. They still can say, yeah, we're not dismissing it. This is what we're offering. That's where we are. So we will have you back here at 1:30.
Thank you.
You're welcome. And Miss Venegas, you were late for court. You were late for court today. Don't be late coming back. All right, Samantha Venegas. Hello. Okay, all right, you're gonna come back here tomorrow and we're gonna have a jury brought up. And whoever, if you decide to hire an attorney, you need to let them know they need to be prepared and ready to go to trial tomorrow. All right, Ms. Ferguson, if you'll give her a reset form for tomorrow, please. All right, thank you. Thank you, Mr. Callahan. All right, I'm gonna call the docket. When I call the docket, you need to answer and let me know you're here. Samantha Venegas. Samantha Desiree Venegas.
Yes, Your Honor.
And she's on bond, correct?
Retro.
Yes. Yes.
The defendant was a no-show for her agreed-upon bench trial, prompting the judge to issue a warrant for her arrest. But now she's been brought back to court and attempts one final, desperate Hail Mary to delay the proceedings. She claims she is now in the process of hiring a new private attorney. This is a common delay tactic used by defendants, hoping to reset the clock. They show up on the day of trial claiming they've lost faith in their current counsel and need time to find someone new. However, this judge sees right through it. Citing that the case has been pending long enough, she denies the implicit request for a delay and declares, "We're going forward with this trial." The defendant's attempts to manipulate the system have finally hit a brick wall.
All right, so Ms. Venegas, if you can come forward, please. All right, it's the court's understanding that you wish to have a bench trial, and you understand what all of that means?
Yes, ma'am.
Okay. State, on this bench trial, how long do you think it would take?
In half of 2 days.
Well, it's a bench trial. So, we have 4 or 5 witnesses, Your Honor, and that's including the drug analyst. Yes. Okay.
All right, so do you all want to confer with Ms. Ferguson when you all would like to do the bench trial?
Sure.
All right, so if y'all would confer on a date, so we won't do your case today since it's going to be a bench trial. Your attorney and the state will confer with the coordinator to see what's the date that works best for everybody involved, okay?
Thank you, ma'am.
All right, and then Norma, if you could see if we could perhaps do this before the new year, if possible. Samantha Venegas. All right.
In a stunning and abrupt reversal, after all the delays, excuses, and no-shows, the trial is suddenly off. A plea agreement has been reached. The defendant is giving up her fight. This is a massive development, but pay close attention to what she's pleading guilty to. The state is proceeding on count 2, possession of a controlled substance of 400 grams or more. To put that in perspective, that is nearly a pound of illegal drugs. The punishment range for this offense is absolutely staggering. A minimum of 10 years and a maximum of 99 years to life in prison. She tried everything to avoid her day in court, and now she's admitting guilt to a crime that could see her locked away for the rest of her life.
All right, Deputy, could you make an announcement for Samantha Desiree Venegas? Thank you. And counsel, I do believe that the bondsman may have filed an affidavit to surrender surety. I'm unable to check because the system is down. We're going to go on the record. Court is calling 2024 CR 008052 and 2024 CR 008054, State versus Samantha Desiree Venegas. Could I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Defense?
Denny Callahan, not ready, not present.
All right, so this hearing was actually scheduled for an agreed bench trial today. Deputy, she hasn't made it back. The court is aware that I believe an affidavit to surrender surety was filed. Is that correct?
I don't know, Your Honor.
Okay. The court is unable to check due to the system odyssey being down. Deputy, did you make the announcement?
But he answered outside, Judge.
All right, thank you.
You're welcome.
All right, State, what are you requesting?
Grant the affidavit of surety to surrender issue the apprehension of the defendant.
All right. And again, the court believes an affidavit to surrender surety has been submitted, but our systems are down throughout the courthouse, so I'm unable to check.
And Your Honor, I apologize for interrupting. If there is an affidavit of surety to surrender, then grant it.
Okay. So what I'm going to do is I'm going to issue a judge's warrant and remand her without bond.
Yes, ma'am.
All right. Is there anything else, counsel?
No, Your Honor.
All right. You're excused.
Thank you, Your Honor.
Okay. I'm going to do that.
Yeah, approach, Your Honor.
He said Project Hail Mary. Yes.
Yeah, approach.
Yes. Yes.
Venegas says she's in the process of hiring Charlie Monk. Monk is tied up in another matter. That's why he's not here today. So she would like him to represent her.
The defendant has officially entered her plea, but her fate is still hanging in the balance. The judge has deferred a finding of guilt and ordered a pre-sentence investigation report, or a PSI. This is a standard procedure in many felony cases. A probation officer will now investigate the defendant's entire life, her background, her criminal history, the details of the offense, and her character, and compile a detailed report for the judge. This document will be the single most important factor in the judge's final decision. The defense is hoping for probation, but the state is opposed. Everything now comes down to what that PSI reveals when they all return on May 13th for the final sentencing.
All right. Miss, could I see the file on her, please, Venegas? All right, Miss Venegas, this case has been pending since September, so we're going forward with this trial. All right, we're proceeding. All right, thank you.
Callahan. Does that agreement include waiving the enhancement allegations?
Yes,
Shall I start drawing up the paperwork?
please.
Bashan, if you can, let me know, they're gonna enter a plea on this case. If you can let me know what is a good date for probation.
The sentencing hearing is underway, and the defense attorney is making a bold argument. He claims his client was merely a pawn taken advantage of due to her poverty and addiction. He's painting a picture of a victim who is trapped, not a willing criminal. Based on this, he asks the judge for a sentence of deferred adjudication, which is a form of probation that would allow her to avoid a felony conviction if completed successfully. This is a high-stakes gamble. The defense is asking the court to look past the staggering amount of drugs, over 400 grams, and see the defendant as someone worthy of another chance at rehabilitation, not a lengthy prison sentence.
All right, the court is calling 2024 CR 008052 State versus Samantha Venegas. Could I have parties announced?
Andrew Harris, Salem for the state.
Benny Callahan defense.
And are you Ms. Venegas?
Yes.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count 1 and the habitual offender enhancement allegation.
Any objection?
No objection.
Did you understand in count 2? You're charged with the offense of possession of a controlled substance, penalty group 1. Let me see here. Less than 400 grams. Did you understand? If you have a plea bargain agreement, I'm sorry. Now it's 400 grams or more. So you're charged in count 2 with possession of a controlled substance, penalty group 1, 400 or more grams. Did you understand? Did you understand the range of punishment for the offense for which you are charged is anywhere from 10 years to 99 years or life in prison?
The judge is not persuaded by the defense's pawn theory. In a methodical and devastating moment, she addresses the defendant directly and lays out why she is not a good candidate for probation. Using the powerful analogy that a criminal history is like a credit report, the judge meticulously recounts the defendant's past. She has been on probation before, only to have it revoked and be sent to prison. She was released only to pick up new charges and be sent to prison again in 2014, 2015, and 2016. The judge presents an undeniable pattern of failure on community supervision. Her credit report is terrible, and it strongly suggests she is unlikely to succeed on probation this time either.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 99 years or life in prison? And also the range of punishment is up to a $10,000 fine. And did you understand that the court could sentence you up to a $10,000 fine as well? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on count 2. They're asking that your punishment be assessed at a cap of 15 years in the prison. There's a $2,000 fine. The state is opposed to your application for community supervision or deferred adjudication. They're taking into consideration 2024 CR 008054. Did you understand that to be your plea? Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Judge.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Be contained in Exhibit 1 and attachments, Judge.
No objection.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. And after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. So we will come back. We can go off the record. We will come back on May 13th. On May 13th, I'll make a decision on your application based upon whatever evidence is presented to me. So I'm going to order a PSI and a TAP evaluation. The TAP evaluation is really to see whether or not you have any controlled substance issues. All right. Do you have any questions about anything? All right. So I've given you a reset form because in case you're released, you'll still know that you'll need to come here And it'll be at 9 a.m. Do you understand? All right, thank you.
Judge, may I approach?
Yes. State versus Samantha Venegas. Could I have parties announced?
Jason Garrett, from the state, Your Honor.
Denny Callahan defense.
And are you Miss Venegas?
Yes, ma'am.
You entered a plea to count 2 on March 26th. You entered a plea of no contest.
Given the chance to speak for herself, the defendant's testimony becomes a masterclass in blame shifting. When confronted with her first probation revocation, she tells the judge she agreed to go to prison not because of her own failures, but because her grandfather, who has since passed away, asked her to. She was 29 or 30 years old at the time. She blames a drinking problem, being young and stupid, and simply not wanting to go report to her probation officer. At no point does she take full, unprompted ownership of her actions. Instead, she consistently frames her past failures as the result of outside influence or youthful ignorance, a narrative that seems to be wearing thin on the judge.
According to your plea bargain agreement, punishment is to be assessed at a cap of 15 years in the prison. There's a $2,000 fine. State opposes your application for community supervision and deferred adjudication. They're taking in consideration 2024 CR 008054. All right, the court will hear argument. Well, before I hear argument, there are some things that defense, maybe you can address with the court. It says in the PSI that her guilt is minimized. And I did read where she's saying that the vehicle's not hers. She knew there was drugs in the trunk, but she didn't throw them away. She didn't do anything about it. So I don't know if there's any insight you would like to give on that.
Yes, Your Honor, I think it's a good inference from the stipulations and the PSI that she was used as a pawn, taking advantage of her poverty and her addictions to methamphetamine. And she's ashamed of that in her life, not only you, but more particularly to her family. There is an element of voluntariness in her actions. There's also an element of being trapped in her actions. And that was one of the things I would ask the court to consider before you assess punishment. I have 3 other remarks.
All right, you may proceed.
And I suggest to the court
After all the defendant's attempts to minimize her role and claim the drugs weren't hers, the prosecutor steps up with one final devastating question. He asks, you had a key in your pocket that matched the lock to the box that the drugs were in, correct? The defendant's response is a quiet but damning yes. In that single moment, her entire defense evaporates. The story of being an unknowing pawn or simply being in the wrong car at the wrong time is shattered. She held the key. This piece of evidence connects her directly and intimately to the nearly 1 pound of narcotics, destroying any claim of ignorance and sealing her fate.
proper resolution of this case because she's still relatively young, deferred adjudication, 10 years, ISF treatment, and she asks you to put her into drug court, which is intensive supervision for every day. That shows some indication of remorse and desire to be rehabilitated.
All right, so here's part of my issues, right?
Yes, ma'am.
One, I have to look at criminal history. And I would have clients sometimes, you know what they would tell me? Why are people looking at my criminal history? We're just here for this. That was in the past. But I would always tell them that your criminal history is sort of like a credit report. And what you're trying to get is probation. So people are trying to say, has she been placed on probation before? You know, will she do well? So it shows that you've been on probation before, and a motion to revoke was filed, and you were revoked and sentenced to 5 years. I know that was in 2007.
Right.
And then in 2014, you were sent to prison for another case. And in 2015, there's a case that you were sent to prison for, and I believe these were running concurrently because it appears that they were running concurrently. And then 2016, again, that's a case. It was running concurrently with the others. So what I'm viewing, it doesn't appear that you would be a good candidate for probation.
May I say something?
Sure. You want to raise your right hand though, because the state may have some questions if you want to say something. All right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Samantha Benavides. I know, okay, I did, in 2010, I went to prison. I was gonna get reinstated on probation, but I took it up with my grandfather, and my grandfather wanted me to go do the time instead of being reinstated on my probation, because he was scared that I was gonna get messed up again and go do a large number of time, and he was gonna pass away.
And
while I
how
was
old were
gone.
you when that happened?
I was 29, 30. And so that's why I chose that. I chose that because my grandpa asked me to do that, and he ended up passing away 6 months before my release. But that is why I was gonna get reinstated. At the time, my attorney was William Reese, and they were gonna reinstate me and send me home, but my grandfather asked me to get it over with. That is why I went to prison.
All right, so you're telling me that. I
I-
could understand maybe there being pressure on you with saying, oh, let me listen to my grandfather and take this time. But at the time you were 29, 30. Okay.
Yeah,
And then the other cases, because you got out of prison and then you pick up more cases.
in 2014, I revoked, I have my parole, and I went back to ISF for the last 3 months of my parole. And then that was done with that. And then in 2016, I went to prison again in 2016. And then I revoked and went back to safety, and I came out and I completed the rest of my probation.
Okay. Why do
Um,
you keep failing that probation?
Of it with parole, the second,
Well, I mean, you
Yeah.
failed at probation and you failed at parole. Why?
the first time when I was younger, I really don't have, I made some poor choices in my life back then, and I was young, I was ignorant.
But no, for the case that you said the first case, you said, I just agreed to be revoked because of my grandfather.
Yeah.
All right, you're telling me then you were 29.
Yes, I didn't
30.
go report.
All
I didn't go
right.
report, and
But then
I had
you-
a drinking problem back then.
Okay.
And back then I would use cocaine a little, and but I had a heavy drinking problem. So I was young, I was stupid, I was living in the bars, basically. And I wasn't, keep out there running the streets or nothing like that. I just didn't want to go report. And that was my biggest downfall right there. If I would have just went and reported and went and taken a UA, everything would have been okay. My life would have been a little bit, different. The other time, when I got out, I violated parole. It was because I came out of dirty UA.
Okay, let me ask you this,
Okay.
because I understand your past. Do you know the amount of drugs this was, the weight of it?
Yes, ma'am, I do.
It's a lot, right?
Yes, ma'am.
Okay, you can continue.
My life for a little while, I was just, I made a lot of mistakes and I'm not proud of it. I'm very sorry for them. If I could take them all back, I would. Now that I'm older, now that I see things differently, and trust me, this opened my eyes. I was doing a lot, I was. I was just trying to, this last offense. I was something, it was just, I was trying to, get by, pay my bills. I was stuck in it. I was just trying to get out of it. And I see now that what it cost me, what it could cost me. And I apologize for that.
No, but here's the thing, you had a previous drug case.
Yes, ma'am.
So I don't understand why you continue to try to build your happiness off somebody else's misery. And when you sell drugs, that's basically what you're doing. You're taking a shortcut and you're building your happiness off somebody else's misery who has a drug addiction and can't stop. And there you are giving them drugs for money.
Correct, you're right.
All right, State, do you have any questions?
Just facts of this case.
Okay.
Ms. Venegas, on this case, you stated that the drugs weren't yours or the drugs were somebody else's.
It wasn't mine, it was in the vehicle.
All right, could you speak up, please?
It wasn't mine, it was in the vehicle, but I was aware that it was in it, and I should have gotten rid of it.
So you're
When I-
aware,
when I
though, you had a
located it.
key in your pocket that matched the lock to the box that the drugs were in, correct?
Yes.
Okay, no further question, Your Honor.
Nothing further. I have one other point, Your Honor.
Yes.
She has family support. Was unable to get finalized letters into your hand indicating that support. That's all, Your Honor.
All right. Ms. Venegas,
Yes, ma'am.
the amount of drugs in this case
Yes, ma'am.
is, let me see, over 400 grams.
Yes, ma'am.
And from what I read in the police report, you're a seller of drugs. And this whole thing about the drugs being in your boyfriend's car and you don't know, you knew the drugs were in your boyfriend's car and you should have got rid of them, but you didn't. It doesn't ring true based upon what I read in the police report, because according to the police report, you're known as a trafficker of drugs. That's what it says in the police report, and that's what was stipulated to. I don't think you're a good candidate for probation. The court is going to find you guilty. The court will sentence you to 15 years in the prison. There's a $2,000 fine. Time and money will run concurrently. The court will take in consideration 2024 CR 008054. I'll suggest the therapeutic community. All right, good luck to you.
May I address the court? She would
Yes.
like drug therapy.
All right, I'll add the therapeutic community.
And one more thing, Your Honor.
Yes.
Would the court entertain a delay in imposition of sentence 1 week and let her go and take care of her affairs?
No.
Thank you, Your Honor.
All right, thank you.
In the end, there were no more excuses left. After reviewing her extensive criminal history and hearing the damning evidence, the judge found that Samantha Venegas was not a good candidate for probation. The court found her guilty and sentenced her to 15 years in prison and a $2,000 fine. In a final, futile move, her attorney asked if the judge would delay the sentence for 1 week to let her get her affairs in order. The request was met with a swift and unequivocal no. From the wrong shoes to a 15-year prison sentence, this case is a powerful reminder that accountability is inevitable in a courtroom. What did you think of the sentence? Was it fair? Let us know in the comments, and don't forget to subscribe for more courtroom analysis.